evening, everyone. Good morning to some in different time zones, and a very warm welcome to our second George Washington Competition and Innovation Lab Türkiye Initiative webinar. I'm Hana Stahiyeva, and I have an honor of leading this initiative in Türkiye, as well as chairing today's session as part of our ongoing activities to foster dialogue on cutting-edge competition law issues in Türkiye and beyond. Today's topic, antitrust in labor markets, peer risks and enforcement in Türkiye, couldn't be more timely. As competition authorities around the world turn their attention to wage fixing, no-poaching agreements, and other HR-related practices, this webinar is part of our broader mission to bring together regulators, practitioners, and academics to unpack these developments and explore their practical implications. So I'm delighted to see an excellent panel of experts who will guide us through this complex and evolving landscape. With that, I'll hand it to our moderator, Dr. Eda Shahin, a senior lecturer at Bath Spa University, who's also an advisory board member of the JV Lab Türkiye initiative, to kick off the discussion. Thank you for joining us.
So thank you, Anna. Before we begin our discussion, I would like to briefly introduce our panelists who bring diverse expertise and perspectives to today's topic. So our first panelist is Mr. Nezir Furkan Kıran, Deputy Head of Department at the Turkish Competition Authority. He has over 8 years of experience at the Turkish Competition Authority, where he has worked on numerous investigations and policy initiatives. So today he brings valuable insight into the authority's current approach to competition, issues in labor markets, and the implications of the recently adopted guidelines. And our second panelist is Ms. Kate Newman, a partner at Nielsen Review and head of the firm's competition law practice. And with over 22 years of experience advising clients across a broad range of sectors, Kate is a leading authority on EU and UK competition law. And today she will provide us with a comparative view, drawing on recent enforcement trends and developments across Europe and the UK. And finally, we are joined by Mr. Mustafa Ayna, counsel at Aktekon. Mustafa is an experienced legal counsel advising both Turkish and multinational companies on competition law, international trade, regulatory compliance. He will offer a practical perspective on how companies can navigate the emerging risks in labor market regulations and ensure alignment with both domestic and international expectations. So thank you all for joining us today. This webinar, as Hannah mentioned, Antitrust in Labor Markets, Key Risks and Enforcement Trends in Turkey and the EU, responds to a timely and growing concern in both policy and practice. Traditionally, competition law has focused on consumer welfare, market power, and anti-competitive conduct between businesses. However, in recent years, there has been increasing recognition that labor markets are not immune to anti-competitive practices and that such practices can have a profound impact on workers' wages, mobility, innovation, and overall economic fairness. So the need for this webinar arises from two parallel developments. First, we are witnessing a wave of enforcement activity across jurisdictions, targeting anti-competitive conduct in labor markets, such as no-poach agreements, wage fixing, and collusive behavior by employers. The European Commission, national competition authorities in the EU, and regulators in the US have all signaled a tougher stance on these issues. And second, Türkiye has recently taken a significant step by publishing the guidelines on competition infringements in labor markets in November last year. And this marks a milestone in Turkish competition law, aligning it more closely with global trends, while also introducing context-specific considerations. Yet practical questions remain. How will these rules be enforced? What should businesses do to ensure compliance? And how do these developments fit into the broader picture of competition law in labor markets? So this webinar is designed to unpack those questions, compare developments in Turkey and the EU, and provide insights from legal and policy perspectives. So let's begin with our first theme today. It is, are labor markets now a new frontier for competition law? So to help us understand this evolving landscape, I would like to start with you, Furkan. So could you please give us a brief overview of how the intersection of labor and antitrust issues has developed in Turkey? Why was there limited enforcement in this area until recently? And what do you think triggered the shift? Is this change reflective of a broader policy realignment or more of a targeted case-by-case approach?
Thank you, Adat. Thank you so much for the introduction and having me. Of course, I just need to start with stressing that my views do not necessarily reflect the views of the Turkish Competition Authority. Back to your question, indeed, we can say there was no effective enforcement until recently. But I should highlight that the idea of harm in labor markets because of the anti-competitive agreements of employers has existed for a long time. Even Adam Smith explicitly described how employers agree on wages to the detriment of employees. However, for a long time, the idea was that labor markets are already protected through labor laws, union laws, and also the idea that competition law traditionally applies only to product markets. And these ideas were taken too seriously by practitioners and scholars. Another reason for the lack of enforcement was the overly narrow perception of competition as something only happens among competitors in output market. But today, labor market bring a sort of a disorienting idea of competition between companies from completely different sectors, and this was puzzling for some. So what triggered the shift? We can point out several driving forces. First, macroeconomic data show that the wage growth and labor share of income were stagnating for most of the countries. And well, this is not necessarily because of anti-competitive agreements, but anyways, the question was if we can use antitrust law to make things better for workers. Second, economic research showed that anti-competitive agreements in labor markets can have severe effects, even sometimes more drastic than in those product markets. For, let's say, a product cartel, we can see prices rise by 2%, which affects large numbers of consumers. So the harm to the economy is obvious. For a labor cartel, even though if fewer people are affected, let's say 2% lost in wages, this directly removes that much of purchasing power from workers. And this is very striking, and this is, I believe, where the authorities started to think that they have been neglecting major disruption in markets. Then in many jurisdictions, including Türkiye, the authorities started to ask whether there is any plausible reason to depart from our main principles of enforcement when it comes to labor markets. For Turkish law, even if we can say this is sort of a regulated market because of the labor laws, union laws, or rules that set minimum wages, but none of these regulations do not exclude the competition law enforcement for most of the markets, except for some exemptions, such as collective bargaining, collective agreements. These exemptions we also acknowledge. But in the end, there was no legal reason to treat labor markets differently than product markets. And we had cases touching on labor markets as early as 2005, where a wage fixing agreement was found to be anti-competitive. But like major self-standing cases in labor markets came later as a part of the global trend. Now we have series of decisions by the Turkish Competition Board, including our latest 445-page reasoned decision from a major self-standing labor market case. And also, as you said, we have our guidelines, a piece of secondary legislation, I believe, that does not refrain from addressing unsettled issues as well, such as the definition of commercially sensitive information in labor markets, or safe harbors for information exchange, or the general framework for ancillary restraint doctrine. These developments indicate that this is not a temporary thing. This is here to stay. But that said, I understand why there is still some debate whether the future of antitrust enforcement in this field is fully settled. And I believe there are indeed various uncertainties across different jurisdictions. For example, in United States, where the agencies were committed, the courts were more hesitant, especially in criminal proceedings. In EU, we hadn't seen a commission level case until the recent global case. This is probably because labor markets are more local, and the global case was unique because of the presence of minority shareholdings that have facilitated the agreements for companies regarding workers from different member states. Lastly, in Türkiye, the major argument was that it is unclear how the authority will implement the ancillary restraint doctrine, but I believe it is more clear now, thanks to our guidelines and also our recent decision. But I can acknowledge that there are still some complex questions that we need to work through.
Thank you so much, Furkan.
Thanks.
So, turning now to the EU perspective, Kate, what do you think has driven this heightened interest in labor markets? Would you say it stems from broader structural shifts, such as post-COVID workforce changes, the rise of the platform economy, or wage transparency reforms? And from your perspective, is there a clear and coherent theory of harm that supports this direction in enforcement?
Thank you so much. And first of all, thank you for the invitation to join you today. And I must also just mention that the views I'm expressing today are my own, not necessarily those of my firm or our clients. I would start by saying I would echo quite a lot of what has been said already, in the sense that labour market issues and antitrust have been around for quite some time. But it's only certainly in the EU and UK that we've started to see the first decisions coming through. In terms of what has been driving this shift, I would say that the role that thriving labour markets play in terms of having a well-functioning economy and a growing and productive economy are very much coming to the fore. That's certainly the case in the UK, where the UK government has given a steer to the UK's Competition and Markets Authority, really to sort of direct the work of the authority towards supporting the UK government's growth mission. And the CMA has said that in taking cases in this area, it aims to ensure that workers are able to obtain a fair value for their work, but also that businesses can find and hire workers at the right price. So very much kind of around this sort of messaging around productivity. And the European Commission also made some similar comments in the Delivery Hero Glovo case that was mentioned a few moments ago. So there is alignment, I think, between the UK and the EU on that. Just a few other observations I would say around what has triggered this focus on enforcement action. Well, certainly, I think where these types of issues arise in markets which are dynamic and growing, I think that would certainly increase the prospect of enforcement action. So if you think about how our life has changed post-COVID, and the kinds of industries that are sectors that are growing rapidly, such as online food delivery, I mean, that would very much be a factor kind of prompting sort of enforcement action. And indeed, that was recognised by the Euro Commission in the Delivery Hero case, where the action was very much articulated in the sense of it being a young and dynamic market where competition should be protected. So I think that is another reason. I'd also, I suppose, point more broadly to the role that dynamic labour markets has in terms of supporting innovation. This came through very clearly in the EU's policy brief published in 2024, where the Commission commented that no-poach agreements reduce dynamism of labour markets because employees do not move to where employers need them. So I suppose that's another theme I would identify. And finally, I would observe that there has been, over time in recent years, perhaps a shift from the focus on downstream markets to a focus on how competition affects upstream markets. So this idea of buyer cartels. And both the UK CMA and the European Commission published horizontal guidelines, so how they look at agreements between players at the same level of the supply chain before these most recent cases on labour market issues, and expressly identified in those guidelines that information exchanging on wages or wage fixing agreements did indeed constitute a business cartel. So I feel like there's been a kind of a ground shift, a movement on that for some time, which has predated these cases. So those would be my observations.
Thank you so much, Kate. So building on that foundation, let's now turn to our next theme, convergence or divergence, Türkiye versus Europe on labor market antitrust, where we will explore how closely aligned the legal standards and enforcement practices really are across these jurisdictions. Here, we will look at how no-poach and wage fixing agreements are assessed and whether companies are facing a double compliance burden when operating across borders. So again, Kate, I want to ask you, how are no-poach and wage fixing agreements treated under EU competition law and UK competition law? Also, is there a per se approach or a rule of reason analysis in either system?
Well, I'm happy to report there is alignment, which as an advisor makes life a little bit easier. So the Delivery Hero Glovo case establishes the legal principle in the EU that a no-poach agreement between competitors is an object restriction of competition. And in the UK, we had a recent decision earlier this year in sports broadcasting, which found that agreements to fix wages, or indeed the exchange of commercially sensitive information about wages, also constitutes an object restriction, and therefore one of the most serious breaches of competition law. So in the UK and in the EU, it's a per se approach.
Thank you. And Mustafa, do you think the Turkish Competition Authority's recent guidelines on labor market restrictions signal a step harmonization with EU competition law, given that equivalent guidance hasn't yet been issued at the EU level? Does the Turkish Competition Authority appear to be ahead of the curve in this area? And how would you compare the Turkish Competition Authority's approach, particularly this identification of certain restrictions as by object, with that of national authorities in EU member states that have issued their own guidance?
Thank you for the question and the invitation. It's indeed a timely and complex topic. So when we talk about antitrust in labor markets, particularly no-poach and wage fixing agreements, we are seeing a global trend toward more intense regulatory attention. So to directly address your question, yes, in principle, no-poach and wage fixing agreements are increasingly treated as serious violations of competition rules both in the EU and also in Türkiye. As mentioned, the Turkish Competition Authority recently published the guidelines on HR-related practices. And I think this guidelines aligns with general approach adopted in the EU. It classifies wage fixing and no-poach agreements as by-object restrictions. It also clarifies that even mere information exchange or informal cooperation in the labor markets can raise serious red flags. Although the rules are nearly identical in EU and Türkiye, companies active in both jurisdictions should be aware of local nuances and not assume that a one-size-fits-all compliance program will be sufficient. Regarding legal standards and classification, we mentioned them, but under Turkish competition law, and especially with the release of the HR guidelines and the recent decisions, we now have a clear statement that no-poach and wage fixing agreements constitute by-object infringements. That means there is no need to show or prove any actual market effects, and the anti-competitive nature is presumed, similar to a per se approach. In the EU level, while the European Commission has not yet issued a dedicated guidelines about HR-related practices, but several national competition authorities like France and the Netherlands have already published their own guidance. And similar to TCA, these authorities also classify these agreements as by-object restrictions. And if you look at the enforcement thresholds and practices in Türkiye, as Furkan Bey mentioned, we can see a shift over time. In earlier HR-related cases, the Turkish Competition Authority was more inclined to issue warnings and requested the termination of the conduct. However, starting around 2020, once the Turkish Competition Authority finds that an infringement has occurred, it has become more willing to impose administrative fines. One of the most important decision is the HR1 investigation or labor market decision. It was quite groundbreaking because the preliminary investigation phase started with just only 3 companies. But after the launch of the full-fledged investigation, it expanded to include 48 companies from very different sectors, such as telecommunication, e-commerce, retail, and these companies are active both locally and internationally. And at the end of the investigation, 21 companies were fined, either through settlement proceedings or the final decision of the TCA. In this case, the competition authority didn't rely solely on direct communications between competitors, but also referred internal communications and interactions with HR consultancy firms. And during the on-spot inspections, the TCA officials obtained a lot of documents and correspondences that demonstrate the existence of a blacklist, grey list, and off-limit practices, and some gentlemen's agreements aimed at preventing employee transfers. Following this investigation, the TCA obviously intensified its focus on HR-related practices and initiated multiple investigations, published the HR guidelines, and the multiple investigations conducted against very different industries like hospitals, private schools, pharmaceuticals, telecommunication, ready-mix concrete. And we also see that nowadays, during the on-spot inspections, the case handlers often include HR teams among the employees subject to review. To sum up, while the European Commission has not yet issued formal guidelines about labor market restrictions, the Turkish Competition Authority has done so proactively. In that sense, we could say that Turkey is one step ahead in establishing a clear framework.
Thank you so much, Mustafa. So, having looked at where Turkey and Europe stand in relation to one another, now let's delve into a more nuanced area. What are the gray zones? Where we explore what kinds of communications between HR departments are still considered safe and where the boundaries remain unclear. So, Kate, there are a number of evolving or somehow uncertain areas of competition enforcement in the HR and labor context, particularly in the EU. Could you give us your thoughts on how authorities are approaching issues such as salary benchmarking and data sharing among employers, informal exchanges between HR professionals, the use of non-solicitation clauses, and more forward-looking concerns like algorithmic hiring tools and AI? Are we seeing a clearer enforcement direction, or is this still very much a developing area now?
Of course. Let me sort of run through a few thoughts in this area. So benchmarking salaries, benchmarking in competition law terms, when properly structured, and that's probably the key thing to note, can in fact be pro-competitive and drive efficiency. I think that's been a sort of well-established view, not just in relation to labour market issues, but more generally. So, and I know from talking to clients that benchmarking is often a very useful tool for HR teams when thinking about how they should or where they should set their salaries. Of course, the key is around making sure that the exercise is structured carefully, so there is no sharing of competitively sensitive information about wages or wage intentions, passing through a third party back to a competitor. So I think the key thing is that yes, I can see that those studies are very helpful, but they need to be structured very carefully. And of course, then care needs to be taken about how the output is used. It's all very well having very careful structures in place for the actual benchmarking data exercise, but then if you have all the recipients then discussing the output of the benchmarking, then of course there could be issues. Of course, sort of comparing that to kind of bilateral exchanges of competitively sensitive information about wages or terms and conditions of employment, for example, with an subjective intention to align on wages so nobody is out of step, as was the case in the UK sports broadcasting case, or indeed in a situation where one competitor gives another competitor, commercially sensitive information, so a sort of one-way flow. I mean, that's one well-accepted principle of UK and EU competition law that can be problematic unless the recipient can show that they didn't use that information at all. So, yes, certainly there are some interesting points to think through there. In terms of informal meetings or discussions between HR managers, in my view, this should not be a grey area in the sense that it's well established that if you were to have, say, two sales managers or sales directors talking about what they were going to be charging for their products or services, that would obviously be very dangerous conduct in competition terms. And I think that can easily be read across to the labour market space. So informal meetings, which include discussions around terms and conditions of employment, what competing employers are doing in a labour market space, are very dangerous from a competition law point of view, and therefore need to be carefully managed. And this is particularly the case where, for employers or for businesses, HR managers may see that their value is actually giving intel to their business about what's happening in the labour market. So, this is an area where I think there is perhaps culturally low awareness about how these issues actually impact on how HR managers do their roles, deliver their roles. So that area I think is very very dangerous and needs careful management if there are forums to which HR managers attend. A very brief word about non-solicit clauses, and this type of question I've been asked quite a lot recently. Are non-solicitation clauses okay or not? And just to reflect a little bit on some of the earlier commentary from the panel, in the EU's policy brief, which was published back in 2024, there was a little bit of discussion there about whether a non-solicitation clause could be ancillary to, say, a joint venture agreement or some kind of vertical arrangement whereby the lawful arrangement will never go forward unless there was some protection that, say, a particularly valuable employee with key know-how or IP or some form of trade secrets, that wouldn't want to be at risk of being poached and being sort of taken away to a competitor. And certainly the view of the European Commission in that policy brief was that that kind of restriction might, and I say might, qualify as being ancillary to a lawful arrangement, provided that the restrictions were objectively necessary, proportionate, and there was no equally effective way of achieving the same aim. So, for example, by using maybe a non-compete type restriction or an NDA or some form of confidentiality restriction. So to me, this feels like a very live issue for business. It's not clear as yet where the authorities stand, but I would say, by way of general observation, that I expect that any form of argument based on an ancillary restriction would need to be sort of very carefully analysed on the facts and would be likely to be interpreted on a strict basis by the European Commission or the UK CMA. And finally, just a couple of words about algorithmic tools. And sort of getting out my crystal ball. I mean, my view is that this is likely to be an area of interest going forward. I mean, the CMA in the UK has been interested in algorithmic tools and solutions for quite some time. There was a case which the UK CMA took a while back around algorithmic pricing tools being used to monitor sales online, and concluded that those tools had been used to implement a meeting of minds between competitors. And you know, it feels to me that this is inevitably going to be an area of scrutiny as we move forward, and when we see, you know, employees using these tools much more in their employment practices. And I think that could be really quite challenging, but we'll have to see how that all shakes out in practice.
Yeah, thank you so much, Kate. So turning to Türkiye, Mustafa, could you briefly walk us through how the Turkish Competition Authority is currently approaching uncertain or evolving areas of enforcement, particularly in the context of vertical relationships? What would you say are considered safe practices in Türkiye today, and are we seeing any notable shifts or gray areas in how vertical restraints are assessed?
I guess you're on mute, Mustafa.
You are muted.
Sorry. Thank you. And I believe that many of the points Kate raised for EU are equally relevant in Turkey. To add some points on benchmarking data gathered from consultancy firms, the Turkish Competition Authority has introduced specific criteria for lawful collection. According to the guidelines, the information exchange must be conducted by an independent third party. It should not be possible to trace the data back to an individual participant. The dataset must be at least 3 months old. At least 10 participants, 10 different participants must include contributions, and no single participant's data should account for more than 25% of the total dataset. It's very crucial to gather these information illegally. As for the vertical relationships, it's not noteworthy to mention that TCA's approach to non-solicitation clauses. According to guidelines, such restrictions are only acceptable if they are directly related to the main agreement, objectively necessary and proportionate. This means the restriction should be clearly written and linked to the main agreement. It should serve a legitimate purpose, such as protecting know-how, and in terms of proportionality, it must be limited to key employees who are essential to the agreement. It must be limited in duration, and it must be has a geographic scope. In other words, restrictions that cover all employees, have no clear time limit or geographic scope, would like to fail to meet the criteria. Indeed, in the recent decisions, TCA also emphasized these points, and unless the TCA will fine the companies. For non-solicitation clauses, there is also one gray area, because for the post-contractual restrictions, the picture is less clear. The TCA has not yet issued a specific assessment on this matter. Neither the guidelines nor the decisions directly address post-contractual obligations. So while post-contractual obligations are not explicitly prohibited, there is also no clear guidance on what duration be considered acceptable after the termination of the agreement. For that reason, when including such restrictions, companies should carefully assess, and the TCA's view is decisive for the post-contractual obligations.
Thank you, Mustafa. So after exploring the gray areas in current practice, let's now look ahead to future enforcement expectations, focusing on how enforcement in labor markets may evolve and what tools authorities are likely to use going forward. So Furkan, could you please elaborate on the potential use of tools such as Lanisa programs, whistleblower mechanisms, sector inquiries and market studies to support more effective and expensive enforcement in labor markets in Turkey. So should we expect enforcement to remain limited to agreements between competitors, or might it extend further, perhaps into vertical or unilateral practices? And what are your thoughts on the need for or likelihood of cross-border coordination in this area?
Of course, Eda. Well, first of all, we have a strong leniency program here in Turkey, and the number of the applications is on the rise. Like since labor markets are a new field of enforcement area, I can speculate that there may be many undertakings now realizing they are or they were part of an anti-competitive agreements in labor markets, and the best way to avoid hefty fines would be a leniency application. That's all I can say. You mentioned whistleblower programs, or we can point out anonymous applications. I believe incentive for workers to report wrongdoings in labor markets, it must be even higher, because these kind of violation directly affects their wages, their mobility. The only problem is that, unlike in those product market agreements, workers most of the time are not aware that this type of agreements exist, maybe with the exception of HR professionals and, of course, senior executives. So these tools will be used, that's for sure, but also sector inquiries to better understand the dynamics of labor markets, since there is no authority with comprehensive legal and economic knowledge in this field yet. And I don't think the enforcement will be limited to agreements between undertakings. I believe that we will see that merger control can play a role. Since textbook economics show that monopsony power of employers can suppress the wages and mobility of workers, it would be implausible to say that we have to prevent undertakings agreeing on wages, mobility, to reach a artificial buyer power, but it is okay them to do that through mergers. We cannot just say that. And in Turkey, our guidelines also states that labor assessments can be part of our merger control regime. But of course, I agree that there is an ambiguity regarding the market definitions and also how to assess efficiencies. Much of antitrust law has built around the idea of efficiencies in product markets, especially in merger control. So the question is how the authorities will assess product market efficiencies when there is also harm for workers. So this is an open question. I know some scholars argue that we have to deem workers as consumers. Then it wouldn't be ideal to choose one group of consumers over another. Similarly, since there are two distinct markets, product market and a labor market, I don't think it would be ideal to justify a merger through cross-market benefits. Another problem is that in most of the mergers and acquisition, there's an affected labor market, because probably parties of that transaction employ same worker groups, workers with same professions, nearly every time. But we simply cannot initiate full-fledged examination every time parties employ same worker groups, same professions. So we will need clear standards, clear threshold to choose which cases deserve deeper analysis. And lastly, you ask about the cross-border coordination. Like the locality of labor markets makes it less likely to see cross-border investigation efforts, I think, but I think we need to see share of information and also even joint research, because it is highly needed, since there is no authority with comprehensive experience in this area yet. That's all I can say.
Thank you so much, Furkan. So, Kate, I want to ask you, is the Hero Glovo fine in the EU an isolated incident, or do you see it as a sign of a broader crackdown on employment practices in the gig economy?
Well, I should first say that at the moment there isn't the fully reasoned decision available for this case, so I'm sort of basing my remarks on the press release and obviously some thoughts on my own. I mean, my immediate response would be no, I don't think it's an isolated case. From what I've read in the press release in terms of the reasons why the European Commission fined Delivery Hero and Glovo as they did, builds very much on the policy brief, and which was published prior to that, obviously, and is very much consistent with the European Commission's sort of stated thinking on those issues. So I think it's a logical progression. So no, I don't think it is an isolated case. I think the bigger question probably is around the sort of cross-border aspect. I think a lot of labour market issues are more likely to play out at a national competition authority level, a member state level in the EU, rather than necessarily be a European Commission case. But I suspect that if the right case on the right facts were to come along, I don't see that the European Commission would say this was just so fact specific. It only relates to this particular sector at all. So I think it's a kind of very clear logical progression on the policy brief.
Yes, definitely. Thank you. So I would like us to turn now to some practical compliance takeaways for companies operating in both Türkiye and the EU. Mustafa, starting with the situation in Türkiye, could you share your thoughts on how companies can navigate this increasingly complex area in practice? Specifically, we would welcome your views on how HR and legal teams can be supported through internal training and awareness raising, the role of risk mapping tools and compliance checklists, improving coordination between competition and labor law teams, and importantly, the types of contractual clauses to avoid, such as no hire or non-compete provisions.
To briefly offer some practical compliance takeaways, first, internal training is absolutely essential, and it must go beyond legal teams. HR professionals need to understand that wage discussions, hiring coordinations, or formal or informal or direct or indirectly contact with competitors can pose serious competition risks. It's also important to keep in mind that in the context of labor markets, the definition of a competitor is interpreted broadly. Even companies that don't compete in products or services, they may still compete for talents. And the second recommendation that companies incorporate labor market risks into their existing compliance risk maps, and the most important one is the non-compete or no-hire obligations included in the agreements. These obligations should be carefully designed and must be assessed not just from only commercial or HR perspective, but also competition law perspective. And lastly, even though the infringement risk is lower in the employer-employee relationships, but non-compete clauses in these agreements should still be assessed also competition law perspective.
Thank you. So before we close, let's bring all the insights together with a final question to our panelists. So if you had to advise a multinational HR team on red flag to watch for today, what would it be? So what is the single most critical takeaway for navigating this evolving area? Kate?
It's a very good question. So quite a few things I would probably want to advise, but if I had to say one burning question, I would say to the HR team, what informal contacts does the team have with its counterparts around the labour markets in which the company operates? As I mentioned before, my sense is that notwithstanding the guidance that's being issued and the cases we're seeing, that sort of cultural awareness of these risks is low, and I would absolutely start with what informal contacts are taking place.
Thank you. Furkan, what would you say?
Well, a little bit similar to Kate. Like, I believe the notion that undertakings should not agree on wages or mobility of workers, it's so straightforward, and it's generally not decided by the HR teams, but the management. In Turkey, we saw HR professionals exchanging sensitive information. It's so common. So my advice will be on information exchange and benchmarking. I can point out our guidelines stating that not only wages, but some of the other working conditions can be sensitive, commercially sensitive information. So HR teams should be very cautious to decide to exchange this type of information.
Thank you. And Mustafa, what would you say?
My red flag also very similar to Kate and Furkan, and it's any coordination, direct or indirectly, on hiring, salaries, or employee movement with the competitors.
Thank you. So we have questions for you, and a question to you, Mustafa. Could anti-competitive HR practices in Turkey lead to criminal liability, or are the sanctions purely administrative?
In Turkey, the sanctions for violating competition rules are purely administrative, so there are no criminal penalties foreseen for these infringements.
And Kate, a question to you. So in light of the CMA's decision in the sports broadcasting case, is it inevitable that the CMA will always seek to take enforcement action in labor market cases?
I think the CMA will continue to be very interested in cases in this area. I mean, the CMA has a range of tools at its disposal to create a deterrent effect in markets and to ensure compliance. So I'm not sure that it would necessarily always be the case that the CMA would take a case all the way through its kind of formal enforcement process, but may well use other tools to try and generate compliance.
Thank you. And a question to you, Furkan. The guidelines of the Turkish Competition Authority state that it is unlikely that no-poaching agreements can benefit from an individual exemption. Do you still expect that companies must apply for an exemption in relation to no-poach agreements?
Well, indeed, our guideline states that no poaching agreements are unlikely to bring efficiencies to outweigh the negative impacts of that agreement. It is in the recent decision that also Mustafa mentioned, the board said there is no efficiency that could be attributed to the no poaching agreements on that case. But even if we assume that there is some efficiency, it still would be difficult to satisfy the other conditions of an individual exemption. If parties can achieve the same objective through individual employer arrangements such as non-competes or NDAs, it would be difficult to say that can be exempted. But if the undertakings think that they have an exceptional case in this regard, they can also they can always apply for it, and it is ultimately up to the board to decide on the merits. Like, our guidelines just saying in theory it would be difficult.
Yeah, thank you so much. So I don't see any more questions. So thank you all for such a thoughtful and engaging discussion. What we have heard today confirms that competition law is no longer confined to traditional product or services markets. It is increasingly shaping the rules of engagement in labor markets too. So as our speakers highlighted, this shift brings both challenges and opportunities for businesses, regulators, and legal practitioners alike. So I would like to extend my sincere thanks to our wonderful panelists, Furkan, Kate, and Mustafa, for their insights, and to all of you for joining us today. We hope this webinar offered a helpful foundation for further reflection and action in your respective fields. Thank you, and I will now hand it back over to Hannah to close the session.
Thank you very much, Eda, and thank you to all the participants, Furkan, Kate, Mustafa, for such a wonderful webinar, wonderful discussion, and timely discussion indeed. It was, I believe the audience will agree with me, it was great to listen to kind of a comparative assessment of what's happening in Turkey together with the EU and the UK to better understand that how important the labor issues nowadays, competition law issues in labor markets, right? My only let's say encouragement is let's stay connected, let's stay compliant, right? And let's stay curious. And until next time, I hope. So I wish everybody a wonderful day, evening. And again, heartfelt thanks to all of you, as well as Channing, who is behind the screens for arranging all the logistics. So yes, guys, thanks a lot and bye-bye.